Well, good morning, everyone. For those who don't know me, my name is John Macris, Paul Endicott sitting to my right. Apologies for the delay this morning. That's what happens when you let a lawyer and an ex-regulator drive the technology. So some smarter people than us have sorted this out for us.
Thank you.
What we wanted to really deal with today in the hour or so that we've got allocated is really look at the changes that came into effect in October 2018 under the Heavy Vehicle National Law. And those changes, as you probably all know, mirrored what was going on in the work health and safety space. So rather than having prescriptive duties, looking at proactive general duties, what we call a primary duty. So we really want to talk to you about what that actually entails. What does it look like in real terms? We're actually going to take you through 3 case studies. And why these case studies have been picked is because these are actually live case studies that Paul and or I have been involved in. And these are cases where there was actually no regulatory action, so there was no prosecutions. The regulators did look into the activities, but certainly there were cases where there was a really good outcome because people took some proactive steps to deal with their particular role in the chain. So they're actually really good case studies in the sense that there was no regulatory action, but people looked at their systems and looked at improving those. So we'll talk about the primary duty. We'll talk about what's reasonably practicable, and for the people from the safety space, you'll know these words, and they've got a very similar meaning in this context. But we'll go through an outline of what they mean. We'll talk about the shift in thinking that you need to really have in these laws, because they did change the way we've been asked to think about heavy vehicle compliance, the case studies, and we'll certainly have some time for questions after that. And I think there's an online function for you to be able to ask some questions, and we'll deal with those at the end of the session. So let's start with the primary duty. As I said, that commenced in October 2018, and really what was going on before that was that the regulators were having to bring multiple charges for very significant breaches because of the way the law was structured. So there were a number of provisions around mass speed fatigue, restraint, those kinds of issues. And rather than saying, you have a general or overriding responsibility, the regulator had to pick each and every activity to bring a prosecution. And so they looked at the safety laws and went, well, that seems to be working really well, this concept of having a primary or a general duty as a PCBU, and they adopted that terminology. So the way that the changes are structured now is they say that each party in the chain of responsibility, and those parties are, of course, your operators, your prime contractors, schedulers, consigners, consignees, loading managers, a number of parties that you'll be familiar with, excluding the driver, by the way, have a responsibility to ensure, and we know those words from the safety context, so far as is reasonably practicable, and we'll come back to those words as well because they're quite important, the safety of a party's transport activities. And this is really the crux of what we have to think about moving forward. It's about safety and transport activities. And what are a party's transport activities? And that really comes down to where do you fit in the chain of responsibility and what is your role? What do you have influence and control over? And that's really where the regulators are now going with your obligations under a heavy vehicle space. And really the intent of all this is to say you really need to have safety management systems in place, as you will be familiar with your safety management system for your safety processes. You really need to think about how do we incorporate heavy vehicle compliance into a safety management framework. And the regulator talks about having 4 key components when you're thinking about this. It's your policies and your documents, it's your risk management, and you'll hear Paul and I talk about risks quite a bit today because it is about risk management. Your assurance, so how do you assure that what's going on is actually what should be going on? And then how are we making sure that our teams, our contractors, everyone knows what they have to do through training and promotion of safety activities. So that's really what they're looking at for us to do. And you'll see it's about being reasonably practicable to eliminate risks, as we know from a safety context. And if that's not practicable, to minimise risks. So we won't be able to, if you want to eliminate the risks of heavy vehicles, don't use them. And that's not practicable. So the next step is, well, what do we do to minimise those risks? And what steps do we need to take? And of course, as you'll see through this session, the answer is really where do you fit in the chain and what do you have control and influence over, right? And this is about really, the regulators are really looking at conduct, because it's those things that really led a change in this law. And what we were seeing was some of the larger trucking companies were saying to the smaller operators, get a truck from Sydney to Brisbane and back by tomorrow, and we'll look after you on the next run or something like that. And it wasn't really captured in any contracts or any emails or any text messages, but it was this nudge, nudge, wink, wink, look after us, we'll look after you. And that conduct is really what we call influence. And influence means your capacity to affect someone's behaviour. And by saying to the other operator, do this and we'll look after you, you're really inducing or encouraging breaches. And what we don't want to see, and what the regulator particularly doesn't want to see, and what the courts don't want to see, is conduct that's going to make people contravene the laws, put people at risk, and put the public infrastructure at risk as well. So that's really, asking someone to do something or not do something, or take a shortcut, or get it there at this particular time without any consideration of how long it actually takes to get there, traffic conditions, the route they're supposed to take, and also, contracts that, we've had instances of people saying, we'll give you this if you do this. Those kinds of behaviours are the conduct that the regulator is trying to pick up in this primary duty. So it's about what's safe, what's practicable, and what are your transport activities.
Okay, a key takeaway for me in that primary duty is obviously eliminate risk. And a party in the chain of responsibility must, as far as reasonably practicable, ensure safety in that party's transport activities. But what is transport activities? Well, it's actually defined within the Heavy Vehicle National Law. And I think to understand transport activities, it's very important to understand our role, to identify our actual role, because you can be captured in many different roles under this law, be it a consignor, consignee. I think we've been through these many, many times, but you can be many roles, can be responsible for managing the risks in each of those roles that you have, but equally other parties can have a similar role and be equally responsible. So you can be responsible jointly and severally for some of the risks that are identified in your transport activities. And transport activities is actually defined as your business practices and the decisions you make associated with the use of a heavy vehicle on a road. Now that's pretty broad. So that's all encompassing really in terms of understanding how deep your responsibilities for the risks go in terms of what you can control and influence. And that's very important. And understanding those risks. So this really asks for us to conduct risk assessments across our transport activities in the roles that have been identified. So a gap analysis should be conducted to identify what party in the chain or parties in the chain you are, and how that associates with your transport activities with the other parties in the chain that you deal with. So that's very important. But let's look at the business activities. So the first thing to understand in terms of the running of your business associated with the use of heavy vehicles, for example, what are your identified activities? That's the first thing that I've just spoken about. What are the risk assessments and controls for removing or minimising those public risks? And as you'll see, public risks. So now we're talking about, for those in work health and safety, a workplace that's now escaped out onto the road network. In other words, into the public, both those out in taking part in their everyday business, but also other road users. Your operating policies and procedures, which is extremely important in giving guidance to the business in how it actually conducts its business. Now, this is often referred to as a chain of responsibility management plan. And probably one of those initial questions that we asked in the poll should have been, do you have a chain of responsibility management plan? And is it suitable for the transport activities that you undertake and your business practices, your human resource and contract management? Now, what we've seen in a hell of a lot of the large infrastructure projects that have been ongoing, that John and I have been in, some of the largest that are ongoing in the country at the moment, is very robust and prescriptive compliance assurance conditions that have been built into contracts. And this assures perhaps the principle that any party that it's going to associate itself with in the supply chain has very good systems. Now, what we don't want in this is to, in some respects, overcook it. What we need to do is we need to understand the risks, in the business practices and the transport activities, and then associate the proper or implement the proper controls, reporting and management of those particular risks so that they're removed, or if not, minimised to the best as possible. And of course, good compliance assurance conditions in contracts is extremely important. in the case studies that we're going to talk to, you will see the use of compliance assurance conditions in contracts has been exceptionally helpful in managing risks associated with supply chains, where corporations and individuals and companies have been able to influence the compliant and safe outcomes that we need to achieve in our transport tasks or our transport activities every day. And in actual fact, this is supported by the Heavy Vehicle National Law. So we don't have in this particular context is, look, it's their problem, they need to look after it. Well, they're the operator. I mean, too many times we see this forced down to the operator and in a lot of respects forced onto the driver's shoulders. And that's not the case. It's about the supply chain and those in a position to control and influence the safety outcomes that we need to achieve. When I said the law helps us and supports us in this, is a section in the law at 742 actually prohibits contracting out our responsibilities, but in another sense, actually supports conditions in contracts that enhance the ability to comply with the Heavy Vehicle National Law. So it is supported and it should be used and it is very effective. Thanks, John.
So one of the things we often see when we talk about compliance assurance conditions in contracts, Paul talks about not contracting out, and that's kind of one extreme. The other extreme I see is people having in their contracts, you must comply with the law full stop, and they use that for their safety clauses and their heavy vehicle and their environmental clauses, but that's not enough itself. And I think I first met Paul when he was working with the regulator, or being the regulator, and he picked me up a number of times when we had some discussions around potential improvement notices in that those conditions simply said you must comply with the law. Now that's not enough. We need to be a little bit more prescriptive in the contract.
In that it was discovered early on that contracts and even improvement notices that said you must comply with the law, and how about you tell the regulator how you're going to do it? And it turned very much around from that fact in let's give guidance. Let's give guidance to people in how they should comply without being captured by the regulations in itself, but equally, so if we were to drill down into the management of fatigue, it would not be unreasonable in this day and age to ask for in-vehicle telematics to monitor drivers' work and rest hours, and equally then speeding, because if a driver exceeds the speed limit, as we can see earlier, it's a breach of the primary safety duty. So giving guidance in terms of compliance equipment, compliance monitoring, those things that give real assurance and can demonstrate that compliance and safety is being managed in terms of the risk. This is about operational delivery of a safety outcome. And that's where good compliance assurance conditions in contracts is very, very effective. And I might say that's being used right across just about all the major infrastructure projects in New South Wales that are ongoing at present. And you can all think of those that are happening through Sydney, up on the North Coast, and all throughout most of the very large off-road sector, as I call them, in warehousing and distribution. So a good management plan that has very good compliance assurance conditions is essential.
So where we want to go to now is we look at the standard, which is who's a party. They have to ensure so far as is reasonably practicable. So we want to get into what that means. And for those of you who are familiar with the work health and safety laws, it is a very similar formula, but not exactly the same. And what this is really saying is, this is really the question in lay speak, are we doing enough? Right? This is the are we doing enough question. And so, Paul used the example of the compliance assurance conditions and the telematics within trucks. If I act for an operator or a carrier, and they come within the notice of the regulator, in every improvement notice I'm seeing at the moment, there will be a requirement to put telematics in. And so what that is translating to is for someone who might be a consignor or a consignee and uses the transport company, they're being told, put that in your contract or your insurance conditions, because that's what we're expecting from the industry, the transport industry. So that's becoming the norm, what you can achieve. That's just one example of how that's become from something that some people are doing to kind of the norm at the moment. And this reasonably practicable is really are we doing enough? And it follows a similar formula to the work health and safety laws, and it says, think about the risks in your operations as it relates to the heavy vehicles that you use or operate, right? So what are the risks? What's the likelihood that something bad can happen to someone or the infrastructure can be damaged. And when we think about a heavy vehicle truck and we put no controls in place and a truck picks up a load, we don't know the condition of the truck, we don't know how heavy the load is, we don't know anything about the driver, we don't know their experience, we don't know who this trucking company is, the likelihood of something happening is going to be pretty bad, right? It always is. The regulator then goes to the next step. So what could happen? What's the result, right? And when we talk about reasonably practicable in any jurisdiction, the result is either fatality through to a near miss, right? And by having our processes in place and doing what we're supposed to be doing, we want to drive all of these to a learning exercise and near miss rather than the fatality or significant damage to an infrastructure. So that range is always that range. Then the regulator or the law says, well, what do you know about the risk? Well, we know heavy vehicles are dangerous. The highest cause of a workplace death is a motor vehicle, right?
In that too, can I just add, without cutting you off here, John, I deal with a lot of people, and this third, I suppose, clause in what's reasonably practical is very important in terms of what should a person know or reasonably to know about the risk in their transport activities. And to me, I ask the question is, what's your core business?
Yeah.
My core business might be manufacturing. I produce widgets or whatever the case may be, and I send them out to supermarkets, or I build buildings, or I build roads, or whatever the case may be. And my first question after that is, can you do it without a truck? And of course, then perhaps my core business turns to transport.
Yeah.
And what should I know about transport, or what should I reasonably to know about the risks in transport? It seems to change the focus. So yes, I do things, I build things, I manufacture things, I distribute things. It doesn't matter what it is. I dig things out of the ground, I grow things, I receive things off farms. It doesn't matter. What should I know about it?
Yeah, and Paul picked up on the point I was going to raise, which is simply, it's not what I know, and for most people it's what I know within my blanket environment, but what should I know if I've got trucks coming in?
That's right.
And that's the key here, and we see this in safety cases every day of the week. You know, what you should know about the risk. Well, trucks are high risk. There are things you can do. There are compliance assurance. We'll give you some examples of these when we go through the case studies. But don't forget the ought reasonably know.
It goes full circle back into risk assessment.
Okay. Yeah.
This all talks back into the primary duty.
Yeah.
This is what it is.
Then the next step is, what do we know about the methods we can take to deal or eliminate or minimise the risk? So what are the controls? And these are not just the controls that you personally know, but what is the best practice in the industry? And that's why I gave the example of the telematics, because it used to be, the regulator used to say to the transport companies, put the telematics in. Now they're saying to the users of trucks, the consignors, consignees, put it in your contract conditions. And that's something that, you know, everyone thought, well, that's not our responsibility to have in there, that's their responsibility. But it's something that you have control and influence over to put into your contracts.
We've even recently seen in improvement notices issued by the regulator, not only fit, and we're not selling telematics, don't get us wrong. This is a really good system, and there's many out there that are very, very good. But by the same token, fit it in your own trucks, but fit it in your subcontractors' trucks if you're going to use them. Now that's taking it to another level. So we're talking about control and influence that's really in a different space. But once it's in an improvement notice, it's the law unless you want to appeal it.
Yeah. And so we get into then what controls are available and suitable. And the problem with telematics, as an example, is the technology is so advanced now. It is so good. And as Paul said, we're seeing improvement notices that it's something you can do in your contracts, in your own trucks, in your subbies trucks, right? So that's where the technology and the availability and suitability of the controls has gone to when we talk about telematics. And that's the regulator driving those things. You'll see that when you get an improvement notice. Now, the law recognises that you're running a business. So the last consideration is cost, as it is when we look at reasonably practicable in other jurisdictions. But the cost has to be grossly disproportionate to the risk of something happening, whether it be an injury to a person or damage to infrastructure. And when we look at something happening to a person, I always say this to my clients in safety cases, it's what's the cost of a human life, right? And cost is your time, effort, money. It took too long, cost too much, was really hard to implement. That's not a defence in these laws. It says, think about these 5 steps, then think about cost, right? Because we're talking about human lives and significant damage to infrastructure. As Paul said, when you look at the formula of what's reasonably practicable, it is really a risk assessment exercise.
It is.
What's the risk? How likely is it? How could it harm you? What do you know about the risk? What are the controls that you can implement? If we don't talk, when the regulator pulls us up or knocks on our door and says, how are you managing the risks? If we don't talk risk assessment or how we're thinking about where we fit in the chain and what our control and influence is, you won't be able to satisfy them that you're doing enough. And Paul, I think, raised in one of the earlier slides, this issue of a gap analysis. Really important. Where are you now and where do you need to be? You need to think about how you do that without, jeopardising yourself. And Paul does a lot of this work and can talk you through it. But the reality is, without that gap analysis or risk assessment or populating your risk register, you're not going to meet the standard because you're not thinking about the risks that may flow from the activities.
In a lot of respects, well, it may be a breach of the primary duty if there's a true safety risk to a person being injured or killed.
Well, if you look at the beginning of the work of the Heavy Vehicle National Law, it says this law sits alongside the work of the safety laws. And the fact that you comply with the Heavy Vehicle National Law doesn't mean you comply with the safety laws. But if someone's unsafe, we may whack you with one or the other. Now, the reality is they can't whack you with both, but they can use both. And technically, the safety laws override the heavy vehicle laws, which really gives us an indication that it's really about safety. The whole thing's really about safety, right? And what it does is it causes us, it really makes us want to think about how do we think about these things. Why we call it a shift in thinking? Because it's not what we've always done. This is a really different way of thinking about safety and where I fit in the chain. And a lot of people said, "Oh, no, I'm just the consignor, so I've got not my problem. I just get to contract this stuff out." Well, that's not enough anymore, because the law says at the beginning of most laws we have something called the objects. So if you go to the Work Health and Safety Act, Section 3 is the objects. This is what this law is about. This law doesn't have an objects, but it has these provisions at the beginning that say this is really about shared responsibility. Trucking safety, infrastructure safety is such a big issue that we need everyone to do their bit, right? And your bit depends on where you fit in the chain, not what you're called, not what your job description says as part of your job, but where do you actually fit in the chain? If you work in distribution, then you've potentially got issues around scheduling, consigning, loading. You might be called a distribution manager, but it doesn't mean you do one thing. You've probably got multiple hats in that role. So the question is, what do we have to do? And it's all about, and we're going to give some examples about this shortly, but it's all about what we can control, what we can actually do, not doing things outside of that scope, but getting the things we can do right and letting other people fulfill their obligations. So this shared responsibility is really driving what this law is about, what we expect everyone to work together and communicate. We call it consultation and safety, but talk about how each party is going to do what they're supposed to be doing.
In this particular area, I think what's important for us to remember, we're here or are we over?
Yeah.
Okay, so moving into our case studies now.
Yeah, just really quickly, I covered this slide, which was really more than one person has a responsibility at any one time. Like the safety laws, as a lawyer, we call it concurrent and overlapping obligations, right? And the big point of this is, and we're still seeing it out there, people want to contract out their responsibilities, right? And we all know you can't do that. And don't even try it with the regulators or the courts, because they, well and truly, if you have the capacity to influence and control, let's talk about influence and control, right? Because we're going to get into some case studies and we'll talk about what this means. There is no definition of influence in any of the regulatory laws. So this, safety laws, right? And so what the court does, it goes to the dictionary definition. It says, how do we influence people? And if you look at the dictionary definition, it's the capacity to affect someone's behaviour. So how do we affect someone's behaviour? Well, that depends on where you sit in the chain, right? So if you're loading and unloading, well, we can affect behaviour because we're dealing with how long the truck is there for, how the load goes on, how it's restrained, when it might leave. If we're dictating when it gets there, when it gets there, right? So there's a number of things that we have influence over depending on where we are. If I'm just ringing a truck to come and pick up some activities, well, I'm not responsible for the maintenance of that truck. It's not my responsibility. We'll give you an example about that. So again, this is about influence. Control is clearly defined in the regulatory laws. Control is about, and when you look at it in the safety laws, it says your ability to compel corrective action, right? So how do we compel corrective action in a heavy vehicle context? So truck comes in overloaded. What do? If we see a driver who might look like they're impaired but we're not sure, what do? If a truck comes in and it's got tail lights hanging off, or there's an obvious issue with the truck that's visibly, what do? They're the things we can control. And I'm not going to give the answers because we're going to talk about those in the case studies, but that's where really this is going. This is saying everyone's in it together. You've got to work out where you are in it and then you've got to do things proactively to address those things that you can control and influence.
I think there's been a lot of commentary on this particular area in terms of control and influence, and if I don't ask, I don't have a responsibility. And we've looked at that over and over as it's been put out to advise industry, and it cannot be further.
And I've done this. I'm not keen to do this testing in court, because the courts are fairly rigid in their view to these things. But when I deal with regulators, and when Paul was a regulator, I'd often go to him and say, we really don't have control about these things, or just trying to stretch the envelope to see how far I could get. And I was often pulled back in, and I have to say to the clients, guys, we can test this, but it's not worth testing, because it's pretty clear you've got to work out where you are and then do the things you're supposed to do. What we really wanted to spend most of our time, I'm not talking to you about what the law says, because you can all read that, but really look at some actual case studies where there were some really good outcomes which didn't result in prosecutions, although the regulators were involved in these cases, to look at some of the measures that you can take which are practicable and where you do have influence and control.
Yeah, so the first of our case studies is manufacturing and distribution. We thought we'd talk to that first, because it appears that a lot of the people who are listening in today are involved in manufacturing and distribution of some sort or another. And think about your own business, I suppose, activities and transport activities, or business practices and transport activities that you undertake as I go through these things, and see if you can stitch them to what you do or the business that you conduct. And align in some respects, and hopefully there be some takeaways. So the investigation commenced into a manufacturing and distribution business that had, and we all understand what a prime contractor is of a heavy vehicle driver. Let's not talk about that. Let's talk about a principal contractor, and that be a heavy vehicle operator that in actual fact is charged with the majority of the transport tasks. And they have a number of subcontractors working for them, as many do. And that's great, sharing the load and assisting with the transport activities. Unfortunately, those subcontractors, one in particular, was coming under notice for their drivers for fatigue breaches of their work and rest hour commitments. Therefore, an inquiry commenced into that subcontractor, and a number of records and documents seized. The regulator, whether it be police or regulator, doesn't really matter at this point in time, issued an improvement notice demanding that the manufacturing and distribution business take control through certain requirements of the transport activities all the way down to the subcontractor. And therein you ask, how can they control that? Well, it was initially undertaken that they discuss within the business a discovery of how far they had control within the business of the transport activities, in terms of they were the scheduler, they were the consignor. In some respect, it was a manufacturing business that brought goods in, so they were also a scheduler in that respect, and also a consignee. They were a loader, a packer, and it was pretty much all encompassing in terms of their responsibilities for their transport activities.
And can I just interrupt? That's something that they weren't completely aware of. So it wasn't until Paul went in to do a gap analysis that the true extent of their control and influence was actually discovered.
Well, at that point in time, it was about just their control. But then we started to look at, well, how far and how correct is this improvement notice in requiring steps be taken to manage the fatigue management of the drivers in the subcontractors' fleets. And of course, there was a review of their principal contractor or transport operators' activities, very cooperative, I might add. And it was identified that there were both failings in terms of managing the risk in both the manufacturing and distribution operations, equally in transition towards the principal contractor. And from that, then, there was also failings through to the subcontractors, and also those risks weren't being managed. So this is a really cooperative approach, albeit that there was an investigation going on. And it was identified that the best way to be able to manage these things formally, we can all have a handshake and we can all have a pat on the back, but let's get compliance and safety to the fore of our transport activities. And what was discussed was insisting on and strengthening our contractual arrangements. We're talking a lot of money in these things too, so there needs to be the ability to provide for the compliance assurance conditions that be asked for in these contractual arrangements, be it in-vehicle telematics, on-board scales, the particular training of staff, which is extremely important. There was issues with load restraint as well, which was things that were identified that weren't being conducted correctly. So there was a change in the business practices across that in policy and procedures. There was a holistic view of a change in safety in this particular business. And this all came from their risk assessments as required in the primary duty. So we have these controls now to minimise the risk, the public risks of them operating on the road. So whilst we had, perhaps you might say to yourself, how the hell in manufacturing do I control what my operator or my principal operator does with his subcontractors? Well, perhaps you don't have control, and that's obvious, but you certainly can influence a safer outcome. And I mentioned earlier how the law supports this. So it's about, do I put my head in the sand and say, well, if I know about it, I don't know about it, then there's no responsibility. Well, as can be clearly seen in some of the regulators' activities, that these things are now at the fore because all they want is they want a quick outcome to safety without perhaps the litigation that goes with it and the expense both on both sides. The winner is safety, and people safety is what it's all about. So that's an example of where we've had a look at the primary duty. We've got each party, if we go back to our early slides, we've got responsibility jointly and severally for the risk in terms of this was a fatigue-related investigation. So they're all responsible for fatigue management. They all have an input into creating a risk. Each of them, both the manufacturing and distribution as a consignor and a scheduler and other roles and consignee, and of course asking for things to be delivered at a certain time, wanting things sent at a particular time, slots booked at the other end, not knowing whether the subcontractor could complete those journeys in those times. So a review of trip plans. A review of trip plans once the trip's been conducted. This is a big gap, a big hole. And of course the revelations out of all these things was really surprising and very scary, I might add. That's manufacturing and distribution.
So when we're looking at that context, well, we're talking about where they sit in the chain. We're talking about really their scheduling practices, their planning practices, their booking practices, the way they engage the contractors.
What was really important in this is, as you'll see on the last line, these were the compliance outcomes. There was compliance assurance conditions in contracts. Okay, that's great. That can be enforceable. So if they're not being done, then you can call the contract into question, as supported by the Heavy Vehicle National Law. So risk assessments and controls, they're the first things that were established. Of course, compliance systems. So systems that talk to each other, that manage these things. So let's not make it difficult. Let's make it really easy for these things to be done. Let's not make it scary. Let's make it simple. And these things are really simple, and you've probably got a lot of it in your business already. Compliance equipment. Well, what do we need to manage these things? We've talked about telematics. It might be mass. There's certain things that we need to do. It might be load restraint. It's really easy to buy the right equipment, but equally what's more important is to just train our people. That's the biggest winner in this, training schedulers. That's so important. The validation that it's being done, and can it be demonstrated? And of course the reporting will be able to validate that to us.
And I think that's where the regulators were taking the changes when saying you need to have a safety management framework. That will capture all of this. It'll all be documented. People will understand it. You can then validate it, check it, audit it. Those kind of things.
I mean, the compliance assurance conditions fall out of the chain of responsibility management plan. The prescriptive requirements of the expectations. That's what it's all about. And it can be very simple. And you need to do this in consultation. Infrastructure and construction. Well, we've had a lot of experience in this over time.
And on the other side of the equation.
But equally, both on both sides of the fences with all the work that's going on at the moment. So the biggest issue that we've found in this, apart from some fatigue issues, but that's managed in some respects also jointly and by the work health and safety legislation in terms of how long we'll work in a particular day, which falls in line. And just in that too, in all my experience with these safety laws, I've never found them in conflict. They've always supported each other. So that's something to remember. And this Heavy Vehicle National Law takes work health and safety to another level in transport activities. Okay, so that's something to always remember. They're very much supplementary. And of course, the principles when I worked at the National Transport Commission assisting on the task force for these changes in 2018, It was about, let's make it the same so that we can actually, not the same, but let's give it the same principle in safety. Give it the primary safety duty. It was a general safety duty originally discussed, but a primary duty to ensure safety in our transport activities so far as reasonably practicable. People get it.
And I think the similarities were about one being risk focused and two being proactive.
Exactly.
That's the
risk.
Yeah.
Risk. And let's talk about safety. Let's not talk about committing a breach. Breaches is another issue. It's not prevent drivers from committing breaches. We get that. But this is about safety, a safer outcome. So we have an investigation launched by a particular regulator who was unhappy with load management, both mass, more importantly, load restraint, and equally heavy vehicle safety and roadworthiness. Now, it's really interesting how the primary duty calls up heavy vehicle safety and roadworthiness. And this is about, and we've got the National Heavy Vehicle Inspection Manual, which is the guidance for regulators and authorised officers in determining whether a vehicle is safe or not. And of course, we have Section 89 and Section 60 of the law that talk about not using a heavy vehicle that's unsafe or permitting its use. And equally, the use of a heavy vehicle doesn't comply with the relevant vehicle standards that apply to it. And of course, if that's established, then it's a breach of the primary safety duty, because if a driver's driving it, therefore the offence is complete. If it has those other elements, we're talking now some serious matters. So we need to understand that in that particular end, the regulator was very unhappy with the standard of the particular vehicles that were being used on this particular infrastructure and construction project. And of course, an investigation was commenced into that. And there were allegations of loads falling and defective vehicles that were produced. And of course, there was a review of the transport activities once again. And of course, then the risk assessments were, I suppose, targeted to talk to how was the vehicle maintenance being maintained of these particular operators, and there was hundreds of them. So this is like herding kittens. So there were some really smart discussions in terms of how to get hold of this. And of course, it then turned to how do we look at our contractual arrangements? Well, there was a failing at the time. The contractual arrangements said, let's comply with the law. Okay, how do we establish that? How deep do we go with that? How can that assist us? What guidance does it provide? Does it say we need to be reasonably practical? Does it say we need to eliminate risks? No, it didn't. It just said prevent breaches. So this is prior to 2018, I might add. So now it transitioned across the changes in 2018 into 2019, further projects and things. And of course then there were those risk assessments that were conducted during those inquiries, which I might say it was really pleasing to see that there was no regulatory action, including prosecutions and sanctions. It was left, the regulator decided to leave it to the principal contractor to manage its prime contractors or delivery partners to manage these particular risks. And of course then the assessment across this was the ability, I have no hands-on operational touch into this. What's my control and influence? Where's my capacity to influence the changes that need to be done? The only way you can turn is to our contractual arrangements, and in that, prescriptive requirements. So what they did is they developed this chain of responsibility management plan, and they put it out there. And they said, you need to come up with a plan, guys, that equals or betters this plan that we've given you. And you know what? They did it. And of course, then it led to a whole range of improvements in safety. Yes, there's a cost, and that needs to be included in whatever you're going to do. And of course, this is the same as a cost in safety. It just needs to be factored in. And the big end of town, I would say, is starting to get that. They start to understand it because they're being pushed. Because the executive, which is in our next session, we're going to talk about those executive responsibilities and where that drives. Okay, who is the best person in the chain to influence the compliant behavioural changes that it needs? And as you can see, the outcomes in this were compliance assurance conditions once again. Heavy vehicle maintenance systems was the key. Safety validation and the ability to demonstrate the same. So are the trucks safe? How do you do that? Do you go and get a brown slip for a truck to ensure it's safe? Not a bad idea. Do you need one before you can start work for us? Well, that's in their plan. That's at the basic level. You remember I said we're herding kittens? What's the easiest way for someone to demonstrate their truck's safe? It meets the requirements in the National Heavy Vehicle Inspection Manual because it's independently inspected. Or you do have a maintenance regime that actually is managed by a Volvo, a Mercedes-Benz, whoever the manufacturer is, to a particular accepted industry standard that you can put your hand on your chest and say, that's covered off for me. They're managing that and they can demonstrate it and they can show me. Do you have to check the trucks? No. Someone standing there with an iPad watching the truck come in, does it have ball tires? I suggest that's a real safety risk that shouldn't be done. Mind you, the person to checking the truck, their ability to check within the requirements of a manual that's so thick. No, I don't say that that's, but you need to validate in some way that these vehicles are safe because you're using them. And the best way I say you do it is through your compliance assurance conditions, and whoever you're using be able to demonstrate. Equally for those operators, how do you demonstrate or how can you validate that a subcontractor that you're using, simply ask them to demonstrate to you, to your level, to your standard, that you've built into your business based on your risk assessments at what you expect as a safe level of compliance and in your particular business and your transport activities. I think that's the way to go with this.
Paul, in this example, one of the when this was happening, I was acting for the infrastructure company and Paul was assisting their client with this process. And one of the questions that arose was simply, I'm an infrastructure company. Do I need to check their licenses?
Yeah, that's a really important thing. Well, licensing is not covered by the Heavy Vehicle National Law at all. It's covered by the Licensing Act in Driver Licensing Act in New South Wales and its regulations. Equally, registration is the same. However, it's probably good safe practice that someone validates, and I suggest be the operator, or if it's an owner-operator, they validate in some way through submission of a document or whatever, or having a document available for you to use if you conduct audits on people, which I suggest you should do. So you have an audit criteria. Do you have a register of driver's licences, and when renewals are due, and are you able to access their records through their permission that their licences are current? That's fine. So if you can validate that someone's doing it, if you're an off-road sector, I suggest that that's not a bad idea. Is it a requirement of the Heavy Vehicle National Law and chain of responsibility? No, it is not whatsoever. It's not covered by this law. But equally, are you going to want drivers on your project driving without a licence? Yeah, okay. Is an unregistered truck unsafe? Not necessarily. Is a registered truck unsafe? Possibly. It weighs up. So what systems you have to demonstrate these things, I say to people, can someone demonstrate this to us? Has someone got a system that can demonstrate? Can you push a button and say, there's a list of drivers and they've all got licenses because we've got a system behind that? Or, but as I said, it's not a requirement. Is it a requirement for you to check trucks that come in to pick up loads from your distribution centre? No, it isn't. Is it a requirement on you not to use an unsafe truck? Yes, it is. How do I validate that? Let's not overcook it. Can someone tell me that they've got a good maintenance system? And this is not just giving me a really inspirational quote. I've got a system. I've got a system, but I can demonstrate to you that my trucks are safe. And that's what this is about.
Yeah. What was interesting in this matter was, on my side of the fence, we were looking at, one of the questions I was asked was, well, if we don't do this stuff and get slotted, what's the fine? And, with the minor breaches, you're talking about at the moment about 11 grand breaches if they're not the significant ones per offence. But what had happened was the amendments at this time had kicked in, these amendments we're talking about, and the offences are now not discrete $11,000 fines. We're talking about up to $3 million fines now.
Sure, yeah.
So if something were to go pear-shaped here, you're not getting charged with the discrete offence anymore, although that's still available. What's going to happen is they're going to bring the primary duty, like they do in the safety laws, invoke the primary duty and look at the bigger fines.
So we looked at this when it first came in, John and I said, I put to him, John, let's have a look at this. We've got use of a heavy vehicle is not permitted if it's unsafe. So we're using heavy vehicle, common term use, or permit to be used. So we're using it, we're loading it, we're putting goods on it to transport, but it's unsafe. And there's a level of risk, and we can talk about the level of risk on a road. We all know that unsafe heavy vehicles certain things can cause injury or death, and we know that, steering, suspension, brakes. And of course then I said, John, let's look at it a different way. We all know that that's a penalty in itself, but it's also an offence for a driver to drive a heavy vehicle that's unsafe. So drivers driving unsafe heavy vehicle, you've used it, there's the connection, and therefore I've breached the safety duty. I've been reckless in terms of, I don't know whether it's safe or not, because I've not asked anybody. No one's demonstrated to me it's safe. Therefore, and someone's been seriously injured or killed, and I'm really up against the wall now. I can't demonstrate I've been reasonably practicable in ensuring safety in my transport activities. Anyway, let's move on.
And just really quickly, just remember, guys, there has been a case in South Australia where a director of a company was charged under the manslaughter laws, the Crimes Act, right? Not heavy vehicle laws, not safety laws, because there was an obvious problem with the brakes of a truck. The truck went out 4 times, even though he knew about it. The truck driver dies as a result of trying to avoid a car.
Yes.
And he was charged with manslaughter, and he got 12.5 years jail for that. So the criminal laws sit in the back of all of this stuff, because these are actually criminal laws. And so the regulators and the police have got different options. And when we get into reckless cases, you know, we've seen it in the safety space in the last 2 years. We've seen a number of individuals being charged and get jail terms, although in most cases suspended. That's where the regulators are going to take reckless cases moving forward.
Just in sum up in that is, as we know that, you know, recklessness to the gross criminal negligence, I suppose, space is an element of manslaughter, and we can talk about 25 years and all the rest, but you'll note that the manager of the operator involved in the crash killing 4 police in Victoria has been now charged with manslaughter. There are certain facts in that, but I won't go into that. But this is where police will take these matters, given that there's elements that support their brief in terms of the requirements in the primary duty on parties in the chain to be able to demonstrate, therefore can't demonstrate very good facts in a manslaughter brief. Anyway.
And that's what, and you don't get to these types of cases where you've actually genuinely thinking about where you fit in. You've got your gap analysis. You're looking at your controls. You don't get to these reckless cases. So that's really why putting this stuff up front proactively is really important.
Just to go very quickly across the last case study, because it is important for some of our primary producers and people that manage things off farm and off the land. And what we saw recently was this was a proactive approach by a particular organisation in terms of a review conducted on their business and a gap analysis to identify, one, their roles and responsibilities in the transport activities, and of course how they conducted their business. Now they're receiving primary produce off farm to the extent of thousands of trucks each particular harvest, and in that their weighbridges were used to pay farmers for the goods that they were delivered. Now, in that, there was a review of those particular records that were held. So truck comes in, it's weighed, the gross weight's recorded, it tips off the primary produce, it's weighed on its exit, and the difference on the agreed price of the primary produce is paid to the grower. Now, it was identified through that, well, we think our weighbridges are used for compliance, but there was a review of the weighbridge records, and in actual fact, there were quite substantial, severe and substantial minor breaches of the heavy vehicle national law, to the extent that it was criminally negligent. In other words, they knew about it. In actual fact, they were incentivising it. And the incentivising it was through, we'll pay you by the tonne. This is grower. So, John, we'll pay you for your primary produce by the tonne. And you can choose how many trucks you want to use. Well, John looks at his load there on the ground and says, well, there's 20 tonne on the truck there. I might as well throw the other 5 tonne on. Otherwise, I've got to pay another $200-300 for another truck. So they were, in fact, inadvertently incentivising the overloading. How did they control it? So firstly, they did a gap analysis across their business. They identified the risks. There was a whole lot of other risks they identified in fatigue management, in scheduling, a whole range of things, how they book slots, but importantly, the mass. And in that, what they did was they improved their recording of weighbridge information. They improved the monitoring of heavy vehicles in terms of who came in at what time did they leave, how long were they on site, and of course those monitoring of the vehicles in terms of the mass requirements. In that too, tell us how much your truck can carry before it gets here. So a record was created of the vehicles that were, and this is a regional area, so that a record was created of the allowable mass limits of these particular trucks based on their axle groups and spacings. And of course, we're not measuring the axle grouping mass, just the gross. And we thought that would be enough based on what's reasonably practicable and the expense involved versus a multi-plate weighbridge and a single player. But we could still get Arctics and truck and dogs, and in some respects B-doubles onto the particular weighbridge. Better staff training and understanding combinations and allowable mass limits. This is extremely important. Stakeholder communication and education, because what they introduced was a penalty system. And in that, if you bring your truck overloaded in the minor category, you get 3 chances and then you're banned. Substantial, you're banned, and severe, you're banned for the rest of the season. But in that, what they did is if you can prove to the chief manufacturer of the product or processor of the product, they would actually give you the permission to return. So herein is a perfect example of I can control my weighbridge. I can't control the loading, but I can definitely influence it. And this has been extremely successful in this particular industry in preventing damage to the road infrastructure, unsafe heavy vehicles travelling on the road. So a safe outcome, again, through compliance influence.
A question arose in this one, this instance, because I was involved here as well, but it's a question I get quite a bit, Paul. It's if a truck comes in overloaded, what do I do? Do I turn it around? Do I keep it? What do I do? Am I incentivising the breach if I keep it? What do I do with it?
This goes back many, many years to a case that RTA then had with a very large primary producer at the time. And in that too, I suppose the thing that was discussed in these particular controls, the same arose. So am I going to, as a consignee, participate in an offence that's already been committed on the road? So if I allow, and we all know now, or some may not, that the responsibilities for a consignee have changed with the introduction to these changes in the law in 2018. Whereas the elements of recklessness, intent and negligence have disappeared, and the same responsibilities for a consignee exist for every other party in the chain. In other words, they must do all that's reasonably practicable to ensure safety. So if we're having overloaded trucks, as in my example I just read out, coming to us, and I continue to accept those overloaded trucks and do nothing, or equally if I was perhaps send letters out and do nothing further and continue to allow these trucks, am I being reckless because it is a safety risk? And I ought reasonably to know that, because that's what it says in the law, because this is my core business. So taking it back, I say that, and in a lot of respects, examples of, particularly in the grain industry, what they'll do is they'll allow you to bring the truck in to prevent it from going back out on the road and tipping that excess out on the side of the road for feral pigs and all the rest of it. They will let you tip off that amount on the side into the facility. You can come back and pick it up, or equally, what you can do is you can donate it to food matter for yourself. In the example that I just said here, if some particular industries, let's say in large recycling, they'll let you tip off, but what they have to do is they have to get a secure zone, a safe place for these vehicles to tip off, and they'll issue then a warning notice, so that then you can't come back until you can validate that you're not going to overload again. So the inconvenience in terms of disincentivising the reward for overloading is clearly evidenced in the fact that you're going to have to wait until we set up a safe place for you to tip off. If you have a really smart think about the safe things that you can do, so I think the first thing is, well, I'm not going to send it back out on the road. I mean, we don't want it back out on the road. But what are the ways that you can disincentivise it in the first instance from it happening again? How can you record you've taken some action? So this is a non-conformance or an incident recorded in your safety system. What's the investigation to it? And what have you done in terms of the controls for future events? That's extremely important in your business activities, your business practices, your policy, your procedure. This is how to manage these transport activities. So turn it away? No. Manage it? Are you responsible for it? No. Can you ask the park it out the front and ask someone to come and manage it? Yes, you can equally do that. The key to this is to record that you've done something that is safe in managing it. You're a safety expert. Is that the way?
Yeah. You know, I've often asked this question of inspectors because I worry about sending a truck back onto the road, right?
Mm-hmm.
This is supposed to be about safety in public infrastructure.
Yes.
My preference is always to park it up on the side, get someone to deal with it.
Yes.
But send them, whatever your non-conformance process is, send them the email, send them the non-conformance notice.
If you're the receiver, the consignor, consignor, I should say, are you responsible for managing it? Not necessarily. If you can, yes. But I think the people that actually send it to you need more responsibility.
You quite rightly can say park it up on the side of the road and deal with it. You can say, yes, I'd rather have it off the road myself.
I would not keep accepting them.
Exactly.
That's where it starts to become an issue.
Yep.
Okay, I think we've got some questions.
Yeah, thanks, John. Thanks, Paul. That session was very informative. And thank you for you both for sharing your considerable knowledge with us. We do have a couple of questions that have been asked throughout the seminar. Now, one of those questions for you gentlemen is, does my COR system need to stand alone or can it be amalgamated into my safety management system?
I'll answer that first and then get John to, when I worked on the task force of the National Transport Commission representing New South Wales and New South Wales Police, the view of the world at the time was, let's not reinvent the wheel. Let's not build another system. And when you talk to business, and I'm talking larger business, we don't want another system. We've got systems that are extremely expensive. Can this work in with the existing safety system? My view of the world is, yes, it should. There are certain parts of it that should stand alone, like your management plan, your policy, your procedures, and all the rest of it. But the reporting should be integrated. And we've discussed this at the highest level. And if it can be integrated into your safety system through the least expensive and the smartest possible means based on the risks that you've identified in your transport activities and your business practices, most definitely it should, absolutely. Because it should report to the executive, which is part of our next session. It should equally report to the executive on your perhaps your handling environment. You're handling your safety and also your transport activity safety. So yes, it should integrate. If you're only a small business, it may not and may be standalone. But the point in this is it needs to be as simple as it possibly can based on the risks that you've identified. So the key is, eliminate or minimise your risks. Go back to the first slide. And of course, are we jointly, severally? Where do I have control and influence? What can I do? And of course, then integrate that into as best you can. That's optimal, but of course, not always possible.
The legal answer is it doesn't matter because under both the work health and safety laws and the HVNL, there's no legal clause that says you must have a safety management system, right? But I agree with Paul in that I think it should be integrated within the system because when you look at the premise of the legislation, it's all about risk. It's all about being proactive. And as Paul said, there are the primary duties and the executive officer liability duties. I would rather have one system that reports into my executive that tells them what's going on. So whilst the legal answer is no, it doesn't matter, I agree with Paul. I think you should have one framework.
Yeah, that's the operational.
Yes.
Yeah. Next one, please.
Yeah, the next one would be, what would my COR plan need to contain?
Okay, a chain of responsibility management plan needs to be based on what your actual business practices are and your transport activities are. But on the basis, there's a long list of things that it can contain. It would contain, I suppose, your general statement and commitment to chain of responsibility.
So your policy, your equivalent of safety policy.
Yeah, and that can be attached to it. It would contain perhaps the governance and audit that you're going to have around it. It would contain the prescriptive requirements for managing perhaps the mass. If you're involved in a particular mass is an issue for you or risk for you, how you're actually going to control your fatigue management, dimension, load restraint, speeding, and of course your heavy vehicle roadworthiness. Whether you're an off-road party or an on-road party, there is an extensive list of requirements that go into a management plan to touch on here is probably difficult, but there are a range of things in terms of the executive officer due diligence liability that you're actually going to put across this. How are you going to meet your primary duties in terms of safety in your transport activities? This is not a book of inspirational quotes, I might add. This is a very prescriptive document that talks about how you're going to operationally manage your risks as identified in your risk assessments. So, you know, the key to this is we've seen a lot of chain of responsibility management plans, and they're really
motherhood statements.
Exactly, across it. We will not let overloaded trucks leave our site.
Well, how are you going to do that?
Well, this is where the prescriptive requirements in a good management plan will talk about. We're going to have trucks that have onboard scales, or we're going to have trucks that have weigh bridges. We're going to have sites that have weigh bridges. Whatever's, you know, reasonably practicable based on all those steps that John outlined earlier is what needs to be put into it. But if someone picks it up, it needs to have the right terminology. It needs to have the right speak. It can't be a regurgitated safety management plan.
The problem I see with a lot of them is the same thing. They're motherhood statements. People just take chunks of the legislation and dump them in there. We won't let people be fatigued. We won't overload trucks. It doesn't tell us how we get there. And you'll eventually have a regulator give you an improvement notice to ask you to spell that out. So you're going to need to spell it out.
Yeah, you'll notice, and I've written a lot of these for the large infrastructure projects ongoing, and it talks about what you need to do and how you need to do it. That's what's important.
And that's the guidance your people will want anyway, because then you train on those things. You can't train on aspirational statements.
No, that's exactly right. One more?
Last question. Could you please expand on the point of being able to provide accurate mass measurements for individual axles versus GVM? Is a weighbridge that can only measure GVM considered reasonably practicable?
Now let's think about the terminology we're using there. So GVM is the gross vehicle mass. This is the manufacturer's ratings for the rating for the heavy vehicle, not necessarily its allowable mass limit or concessional mass limit or whatever, the higher mass limit. So vehicles in some instances can be loaded to their GVM, but can never exceed their GVM or allowable mass, whichever is the lesser. Just take that in. So for what's reasonably practicable in terms of a weighbridge, if you were to have the majority of vehicles, and mass be a particular issue for it, the law doesn't say you have to have a weighbridge. It's about managing, going back again to the risk assessment and what's reasonably practicable. So is it reasonably practicable to have a 5-plate, multi-plate weighbridge to manage the mass on B doubles, or can I have a single plate weighbridge and move the vehicle forward across that weighbridge to measure its axles to get a reasonably practicable assessment of the mass? What it's saying to you is, you know, do what's reasonably practicable to ensure the vehicle is safe, and in that its mass doesn't exceed its allowable mass limits. Now, if you were to have a single plate weighbridge, which many people do, would the law require you to fit a multi-plate weighbridge, or would it be reasonably practicable to do that? I would suggest you not do it. But equally, if you were to be going across the Marulan weighbridge or the Mount White weighbridge and you're being picked up by the screening lanes and brought in and bridged for mass, then it may be that the regulator would issue an improvement notice asking for a multi-plate weighbridge, or equally for your weighbridge that you've got to be upgraded.
Yeah.
So I wouldn't suggest that if you have a single plate weighbridge, it's about a risk assessment of the type of vehicles that you're weighing, and can you accurately weigh those? And you'll know that with yourself. And if you've got an expert that comes in to assist you with calibrating your weighbridge, a decent discussion, a gap analysis across that, some good documentation to support your decision-making process in terms of the decision I made was reasonably practicable. And of course, we've had maybe an independent assessment of the mass of those vehicles, hopefully not across a regulator's weighbridge.
The other thing about weight is the technology evolves so rapidly that you need to think what's out there in the market as well.
Yeah.
So there's lots of wonderful whiz-bang things that people are developing, and you just need to stay in front of what's going on out there.
I think so.
Because it may not be a multi-point weighbridge is the way to go. It might be something else. So,
and it could equally be that you don't have a weighbridge. Would I install one? Well, could you say that it may not be viable for me to install one on my
Because
site?
you don't have the space or something.
Whatever. And you could have then ask for vehicles that are coming to you to have onboard scales.
Yeah.
And have a system to record their mass. There's many options, and I don't go for the simplest, but sometimes the simplest and the cheapest is a really good viable option. But equally, you need to be able to assure yourself that whatever decision you make is safe. I think that sums it up. Yeah, nothing to add.
All right. Thank you, gentlemen. Thank you very much for your time. That's probably where we'll wrap it up today. Look, I would say to all of the attendees, if you do have any questions or you would like any further information on any of the topics that were discussed today, we can be contacted at www.zenergygroup.com.au. Again, thank you, gentlemen, and we appreciate your time.
Thanks, everyone.
Thank you.
Thank you all.